Thank you, Madam President. Members, in 2002, Senator Steve Peace and I authored a pair of bills, Senate Bill 1386 and AB 700, which taken together comprise California's security breach notification law. The law has worked surprisingly well because it is simplicity itself. It says that whether a governmental entity or a business that holds your data loses that data, it has to tell you so that you can take steps to protect yourself. That simple tool has meant that millions of American consumers have known when their personal information had been disclosed and that they were at risk. It also means that there's been a powerful incentive on the part of both government and business to improve their data security. 5 years have passed, and in those 5 years, more than 40 states around the country have modeled their laws, similar security breach measures, on California's law. That law has also been the basis for discussion in not only our nation's capital, but in capitals around the globe. What have we learned after 5 years? We've learned that the law works well, but that there are some improvements that would make a good law even better. They're very simple. Provide greater clarity about what ought to be in that notice, and make sure that news of that security breach also is reported to the state. The benefits: greater ability by consumers to protect themselves, greater clarity for businesses about making sure that they have in fact complied and are not at risk of failure to comply because of the ambiguity that currently exists, and the ability of law enforcement looking at a central repository to understand if there are patterns or practices that they should identify and pursue. We have taken an amendment recently, members, to remove the requirement for posting this information on the website. That has assuaged the concerns of some previous opponents. Measure came out of the Appropriations Committee on a 12-to-1 bipartisan vote. I would respectfully ask for an aye vote.